Hi, everybody. Welcome. We're just going to wait a couple more minutes for everybody to fly into the virtual room. And we'll get going in just a minute. All right, hello everybody. I think that our participant list is stabilizing the numbers, so I think we can kick off now. You're all very welcome to join us here at the City Law School virtually for today's webinar, hosted by the Institute for the Study of European Laws, the EU Law Research Centre, co-directed by myself and my very fantastic colleague, Professor Elaine Fahy, whose events you may have already attended in the past. Thank you all for joining us on this, at least if you're the UK and in the south of England, a very sunny day. I know that today is the day where we are allowed to meet 6 people outside, and we indeed have 6 fantastic people in this virtual room. So I hope that it is worth all your time to stay in and meet us all instead. So today's webinar is about citizens' rights and the EU settlement scheme on a very, let's say, auspicious day, perhaps, the 29th of March 2021, which is 3 years on from the original date that the UK would have withdrawn from the EU had it not been for all of those famous delays that I'm sure you're all very much aware of. So I'm delighted to welcome you all today. We have some fantastic speakers from all different parts of the academy and also in practice, legal and otherwise. So I think that this interdisciplinary group will be very interesting. You'll find their findings and their research very interesting. We will get going in just a second, but before we begin, I just wanted to bring your attention to a couple of other events that we have on, in case you're interested in joining us throughout April. So as I mentioned, my co-director, Professor Fahy, has organized other events on the Law Facebook, an environmental law book talk, both in April and then at the end of April, one on transatlantic trade and the Technology Council. So if you are interested in any of these events or interested in our work at City in EU Law, then please do follow us on Twitter at citylaw_ISEL. We will be having some fantastic tweets today, live tweeting the event, and the recording will also be available after the proceedings. And I suppose this simply leaves me to introduce our first speaker and kick off the proceedings, if everybody is ready for that. So first off, we will have the non-lawyers. So we have Dr. Mikola Benson and Professor Nando Sigona, who are leading a project, collaborating on a project, which is an ESRC funded project under the Governance After Brexit call, if I'm not mistaken, named Rebordering Britain and Britons After Brexit, or MIGZEN. They'll tell us all about it. Mikola is a reader in sociology at Goldsmiths University of London, and she also had her own project under the ESC Governance After Brexit call in the first round. You might have heard of it, Brexit Brits Abroad, or the Brexpats Project. And she's now working with Professor Nando Sigona, who is the chair of International Migration and Forced Displacement at the University of Birmingham, but also the director of the Institute for Research into Superdiversity. And they are kicking off a new project, which is a very interesting way to start our proceedings today, given what has happened since, those fateful years ago when the UK voted to leave the EU. And I will let them take it away. Thank you very much, Mikola and Nando, for joining us today.
Okay, so we've decided today that I'm going to present, and then when we come to Q&A, Nando will come in. It seems to be both of our fate to be working on Brexit perhaps for the rest of our lives. We both had research funded through the UK and a Changing Europe originally to look at, in my case, what Brexit meant for British citizens who live in the EU, and in Nando's case for EU families and the children of those EU families in the UK. And that both of those projects came to an end, I think, sometime in 2019. Actually, kind of just before we entered the transition period. But what we wanted to do today, we'll go into a little bit more detail about what those projects concluded, as well as this new project. Sorry, I started at the end rather than at the beginning of the presentation. So I'm just going to introduce you very briefly to what we've already found and kind of the basis that we're building on in moving forwards. So I'll start with talking about the Brexit Brits Abroad project. This was a project that I led at Goldsmiths, looking at what Brexit means for British citizens who live in the EU. And when I first wrote the proposal for this project, it's really difficult to believe, but we actually didn't even know anything because Article 50 hadn't been triggered yet. So I got the funding, I started the project, I think, for this, like a few days after Article 50 had been triggered. And I don't think anything prepared me, or indeed the people who took part in the research, for what would be the next kind of 2.5, 3 years. As we kind of started on a process of agreeing the withdrawal agreement, well, deciding on what the withdrawal agreement would look like and what that would mean for people who had already exercised freedom of movement. So the British citizens who live in the EU, estimated somewhere in the region of 1.2 million, are kind of the other side of the story when it comes to Brexit and citizens' rights. And I was very keen that this population, who is so often overlooked, but also quite heavily caricatured and stereotyped in ways that really undermine the actual diversity of that population, I was really keen that they didn't slip out of view. And over the course of 2.5, 3 years, we worked very closely with British citizens who lived all the way across the EU, from a range of different backgrounds, across all of those different axes of social division that we might want to think about when we're thinking about any major change. So we looked at gender, we looked at disability, we were very, very attentive to those kind of existing inequalities, the existing stratification within the population. And perhaps unsurprisingly, what we discovered was Brexit as a process was unevenly felt and experienced by British citizens living across the EU. And those privileges that the privilege of having access to free movement, as that kind of unraveled, we saw how Brexit was interplaying with pre-existing vulnerabilities, how it was generating new vulnerabilities for those populations, for those individuals. And we started to also see how people were variously positioned to respond to the challenges that Brexit was placing on their lives. So I think that really, if I had one takeaway point that I wanted to share with you today, it's that the impacts of Brexit started to actually show themselves in the lives of these British citizens, or some British citizens, even before anything had actually changed in terms of their legal rights and entitlements. And they continue to show themselves in people's lives at the moment. I mean, I was caught up in a kind of a strange, well, not a strange a Twitter conversation last night about an article that had been published in The Independent, where a British man who'd lived in Spain, who'd voted to leave the EU, had found suddenly that he wasn't actually eligible for residency in Spain, and so he was having to leave Spain. And I won't go into the kind of vagaries of the discussion that was ongoing around that. But all of that is to say that it's continuing to have an impact on people's lives as we start to see that implementation process playing out. And it will continue to have an impact on those people's lives for many years to come. So I'll just move on to Nando's project. It feels a bit strange to be reporting on somebody else's project, but I think what you can see here is that even when we start to look at EU families and Euro children, there's a similar register here. Brexit as a process being unevenly felt and experienced by EU citizens, by EU families in the UK and Euro children. And just like us, they were able to document everything from the kind of initial feelings about Brexit, those ideas about frustration, anxiety, and disappointment, into looking at actually how, how those kind of emotionalities interplay with different circumstances, different situations. So it's one thing for everybody to say, oh, we're shocked, we're upset, but it's very important for us to have a look at the way in which that actually translates into real life impacts for people beyond those kind of emotionalities, I think. And what this project did with its focus on the family was really look at those, the attention to the life stage, how life stage impacts in that, and how gender was essential there for understanding the more nuanced impact of Brexit, but also what families were able to mobilize, what resources they were able to draw in order to mitigate the impact of this. And I'd really recommend that you look at the website of both of the projects to find out more about what we've done. This was, in both cases, incredibly in-depth qualitative research. In Nando's case, paired with some quite important statistical analyses around naturalization, around repatriation of EU citizens and onward migration, as well as actually looking in depth at the statistics that were available and trying to really map where these EU citizens, where these EU families were and how they were constituted. Because of course, in a lot of cases, EU families are actually families which also include British citizens. And I think that this is something that we need to be critically aware of. So from there, we have come together, and we've come together to think about what happens next. And we really were thinking about Brexit in terms of what this means for the future of, how can I put it, like the future of Britain's borders and boundaries, and thinking about what this moment does in terms of our understandings of the political community. And what we wanted to talk about was how Britain's migration story has long played into that, but that this is a new moment as the kind of the populations of who might be considered as not a member of the political community expands to include those EU citizens who now will find themselves newly bordered on entering the UK. How we have a discussion around migration in this country that's actually attentive to emigration, whether that is the emigration of British citizens or whether it's the emigration of EU citizens and other third country nationals, for example. So we're really trying to kind of say, okay, this is a moment for us to rethink again about the migration story and to pay attention to the role of that migration story within public and political understandings. And so we've designed a project that tries to bring in, that will speak across these different levels, across these different populations, to really take a close look at, up close at this process of rebordering Britain after Brexit and consequence of Brexit, and see its kind of impacts. So what we're going to try and do through the project is look at how and in what ways Brexit has kind of intervened in the volume, geography and direction of migration flows between the UK and EU. And think broadly about how that sits in respect to kind of global migrations to and from the UK. And I'd just say there that the point about that is that in terms of something like emigration, the flow of British citizens to the EU was such a substantial proportion of all emigration that it would be really interesting to see how that now, the ways in which that transforms that in terms of who's moving, where they're moving to, etc., etc. But we also want to follow up with the people that we worked with on the previous projects, British citizens resident in other EU member states, and EU citizens living in the UK, to kind of revisit with them how they're thinking about their mobile and residential futures in consequence of changes to their legal status, but also their personal and economic circumstances. And we want to make sure that we locate this appropriately within a context that sees that, you know, Brexit is one major piece of transformation, but there are others ongoing as well, political and economic crises across Europe, as well as, of course, the COVID-19 pandemic. And finally, kind of looking forwards in terms of people who are newly migrating, we want to look at how those transformations to migration governance regimes brought in the wake of Brexit intervene in decisions to migrate and repatriate, but also how those then shape or interplay with the subsequent experiences of settlement of those newly migrating between the UK and EU after Brexit. So yeah, so that's the project. It's a very broad brush introduction to what we're going to be doing. As you can probably see, it's a very large project that will take us, you know, that we've only just started, literally. We're recruiting postdocs at the moment. So yeah, it's early days, but watch this space.
Thank you so much, Michaela, and looking forward to hearing from Nando. I hope that you guys all have some questions for them both. And of course, we'd love to hear a little bit maybe later about what your initial kind of findings or hypotheses are. Just to say that I forgot to mention that if you are attending this webinar, then you will be able to see the Q&A button at the bottom of your screen here on Zoom. Please do feel free to put questions to our panelists as they speak and as they come to your mind. I'll collect them all at the end, and we'll put them to the specific panelists themselves, unless you have a question that, of course, is open to everybody. So thank you so much, Michaela and Nando, for that very good introduction to the kind of foundations of our history of this, you know, Brexit and everything, and citizens' rights in particular. I'd now like to introduce our second speaker, Rhys Davies, and we're very happy to have Rhys here today. Rhys Davies is the General Counsel at the Independent Monitoring Authority for the Citizens' Rights Agreement. This is a brand new body that was established at the end of last year, and Rhys is going to speak to us about what they do, how, you know, we will perhaps use them, a little bit of the work that they do as they are a new body, and as a lawyer, very much trained to do so. So thank you very much, and take it away, Rhys.
Thank you, Adrienne, and thank you very much for the invitation to come and speak at this webinar tonight. I think I have to, in the interest of open transparency, I have to say that there was a selfish reason, in part for that, but I will come onto that later on when I'm speaking. So I thought that I would first of all just take you, or take listeners to the withdrawal agreement and the EEA-EFTA separation agreement and what that says, and specifically what it talks about monitoring of the implementation of the citizens' rights provided for under those agreements. And for those of you who are familiar with both agreements, there is a provision there which requires the UK to put in place an authority, an independent authority to monitor the implementation application of the citizens' rights afforded under those agreements. And if you look at the agreement itself, it talks about powers equivalent to the Commission, and that the body will be able to conduct inquiries and receive complaints to inform those inquiries, and also talks about the ability to take legal action to secure an adequate remedy where there are breaches of the Part 2 of the withdrawal agreement. And in the UK, the UK government decided to implement that requirement in the form of the EU Withdrawal Agreement Act, which was passed earlier in 2020. And specifically in Section 15, Schedule 2 to that Act, the Independent Monitoring Authority was established. And in terms of what the Independent Monitoring Authority is, it is a non-departmental public body. So it sits independently of government, but is also sponsored by the UK government and specifically the Ministry of Justice. However, the Independent Monitoring Authority is fully independent of government. We have a board which recently met a couple of weeks ago. That's its third meeting, I believe. So that board sits apart from government and sets the strategic direction of the IMA. And the board is currently chaired by Sir Ashley Fox, and we have members from across the UK and Gibraltar. And I think that kind of leads me to one thing that I would specify at this early stage, is that the Independent Monitoring Authority's geographical remit stretches across the UK, but also Gibraltar. So that is something that we are cognizant of, and we have members on the board which represent that fact. So we have members from Scotland, Northern Ireland, Wales, and Gibraltar, in addition to those members from England. So in terms of what the IMA can do, so I've mentioned briefly or made reference briefly to some of the functions that are set out in the withdrawal agreement, but the Act gives a little bit more clarity on what exactly the Independent Monitoring Authority can do. And I think the first thing I'd mention is our ability to receive complaints. So those are complaints from individuals who feel that their rights under the withdrawal agreement or EAF, the separation agreements, have been infringed. And we review each and every complaint we receive, and we decide on what course of action, if anything, that we need to follow up from those complaints. And we've been receiving those complaints since we went live on the 31st December at 11 p.m. So that is when the IMA became fully operational, although before then we had been in shadow form, as it were, for a few months beforehand. The next function that we have at the IMA is to carry out inquiries. And specifically, we have 3 routes that can lead to inquiries. So one of which I've just mentioned, is through complaints. So if we feel that complaints identify general or systemic failings in how the citizens' rights under the withdrawal agreements are being implemented, then we can carry out an inquiry on the back of those complaints to look into the situation and seek to identify whether there is in fact a breach. The second avenue for an inquiry would be by way of our own initiative powers. So the IMA not only relies on complaints from individuals who feels that their rights are infringed, but also from, we have our own function where we collate and gather information and intelligence from a variety of sources on what's going right in terms of implementation of the withdrawal agreement, but also specifically and more importantly, what's perhaps is not going quite as well as it could have, or where things are just going badly. And we would use that information then to initiate our own inquiry. The third avenue is on request. So the governments across the UK and Gibraltar can all make requests to the IMA to carry out an inquiry. And so those are the 3 routes, and how the inquiry then plays out will depend on the issues at hand. But it will also always conclude with a report which will set out the IMA's conclusions and also recommendations for the relevant public authorities concerned, who the IMA may feel could do things slightly better or differently to ensure that the rights of citizens are enforced and protected. The relevant public authorities will then have 3 months to consider those recommendations and then set out its responses in terms of what it will do in light of those recommendations and what action, if any, it intends to take. And then the last set of functions that I thought I would mention also was the IMA's powers to consider legal action. So we have litigation powers to take legal action, but also to join existing proceedings. And those are powers that we will consider using where we feel appropriate to promote the rights of citizens under the withdrawal agreement. So those are, in general terms, our main functions. And I think there is something to be said around, just talked about the litigation powers in terms of enforcement, and it's really important that there is a body there that can enforce these rights. But it's also, I think, worth emphasising the way in which our function can be used to promote good practice, as well as picking out bad practice. So in those, through those inquiries, where we are identifying good practice, we will also be sharing knowledge of where things are going well. So that is an important element of what we will be looking to do. In terms of how things have been going so far, so I've mentioned that we've been live now for nearly 3 months, but even before then, our work had started. So in the months leading up to the end of the transition period, so 31st December. And one of the key challenges that we tried to address in those early months and are still trying to do so today is around raising awareness of the IMA. And that brings to my rather cryptic reference earlier about one of the selfish reasons of coming along here today is around promoting awareness of what the IMA is and what it does. And that is key because the IMA will only be able to act insofar it has the information to act. And therefore, it's really key for the IMA to ensure that those citizens who are directly affected by the withdrawal agreement know of the existence of the IMA and are able to register their complaints, which is can be done online via the IMA's website. There is a portal there through which individuals can report their complaints, but also to the other organisations, which there are many working in this field, who themselves may come across general or systemic failings, who feel able that they can pass on information to the IMA, who can then use it to form or inform how it will exercise its functions. And in terms of that stakeholder engagement, I mentioned we are very active. We are speaking to a whole host of different organizations. So that includes speaking to representative groups, that includes speaking to embassies, and also speaking to the public authorities that we will be monitoring. So there's a lot of work that's ongoing to make sure that people are aware of who we are and what we're here for. And recently, so as of last Friday, we published our first quarterly newsletter, which is available on the IMA's website for those of you who are interested and who might want to subscribe to that, which talks about what we're doing, and we'll give updates on future work that we intend to do or have been doing. And then the other thing, element of our work that I was going to mention is a recent survey that we've undertaken. So we carried out a survey a couple of weeks ago, which sought views from the EU and EEA citizens on their experiences in the UK. And specifically, we were keen to hear their views on their confidence that their rights would be upheld by public authorities in the UK, as well as both awareness of the Independent Monitoring Authority itself and also the EU settlement scheme. So as I mentioned, that survey closed a couple of weeks ago. We are currently monitoring or analysing all the information from that and hope to use that in due course to see where we go next. And I'd also make reference to the fact that we'll be publishing a couple of documents in very short order, specifically one of which will be the guidance that we are required to publish, which sets out how we intend to operate and how we intend to exercise our functions. So that hopefully will give those of you who are attending here and anybody else who's interested to see how the IMA will operate more detail on that. And I think that probably concludes what I wanted to talk about tonight. So I look forward to any questions that you may have at the end. Otherwise, I'll pass you back over to Adrienne.
Thank you so much, Rhys. I think it was also one of the objectives of today's webinar, especially on this auspicious date, as I mentioned, to bring attention to the work of the IMA as a new body. So very happy to hear of the work that's happening, and do please ask any questions if you have any in the chat, and hopefully Rhys can shed some light on them. So thank you very much, Rhys. We can now move swiftly on to our next group of presenters, Professor Charlotte O'Brien and Dr. Alice Welch, both from York Law School. They are the two people representing the EU Rights and Brexit Hub. Professor Charlotte O'Brien is a professor in law at York Law School, and she heads up this fantastic hub. It is another ESRC funded grant, as I understand it. Lots of Brexit work, very good work happening with citizens' rights. And Dr. Alice Welch, who recently received her PhD at York, is now working as a research fellow on the EU Rights and Brexit Hub. Very delighted to welcome them both today to speak about the work of this hub, which is a body that I think helps EU citizens. So hopefully if this is something that you guys are interested in, then they will be able to shed some light on it. And I will just leave them to it. So take it away, Charlotte and Alice.
Great, thank you. And thank you so much, Adrian, for organising this and for inviting us to speak here. What we thought we'd do is Alice and I'll do a quick introduction to the project and then move on to talk about some substantive issues relating to the EU Settled Status Scheme, issues which have been anticipated, I can see, by Tammy Harvey in the Q&A comments. So the project that we're working on, the background to this project is that a few years ago I was working on a project which was also ESRC funded called the EU Rights Project, and it was a bit of a one-woman band. I gave advice to EU nationals through citizens advice officers. I was working in different CABs and also doing a bit of second tier work, doing face-to-face advice, doing representation, going to tribunal, etc., and documenting the obstacles that we were encountering in a advice-led ethnography. And this proved a really fruitful way of discovering things that were going wrong that I don't think otherwise would have been picked up by observation-based research or by generalist advisors. So it was kind of bringing the expertise to bear on real cases. And then this, just as this project was finishing, there was this little thing you may have heard of called a referendum on EU membership. And spoiler alert, Leave won and the UK has left the European Union. And if we thought things were complicated beforehand, and they were, then we ain't seen nothing yet, really, in terms of what's coming. And that inspired the application for funding from the ESRC under the Governance After Brexit programme to do another legal action research project, so advice-led ethnography again, but this time it's second tier. So the idea is it can be nationwide, a nationwide hub. We work with organisations around the country, including Northern Ireland, to give advice and support and offer drafting support to organisations who are working with EU nationals trying to access public services. So that can be benefits, it could be housing, education or healthcare. And again, documenting the obstacles that we are encountering. Now, the focus of our research is on EU nationals who fall within the scope of the withdrawal agreement and the scope potentially of the UK EU Settled Status Scheme, i.e. those who were resident on and before the 31st of December 2020. There is a degree to which I'm sure we'll be looking at new arrivals, but given that the immigration regime has changed so radically and fundamentally, it will be a fairly different exercise, and therefore our focus is very much on the EU citizens who are, I think Elena Spaventa has termed them Brexit citizens, so those who are caught in the midst of Brexit, who have exercised their free movement under EU law when EU law applied in the UK, and are now dealing with the fallout of that. And now I'll hand over to Alice.
Thanks, Charlotte. So I work as a research fellow on the project, and I'm mainly focusing my work at the clinic part, which is the part that Charlotte just mentioned, the second tier advice arm of the project, and also some evidence collection that we do there. So we don't only help individuals with cases, but where advisors are finding that there's relatively easy fixes to cases, they can tell us. And then we can track if the problems are actually bigger than just on an individual basis. Some examples of what we're starting to see, unsurprisingly, existing problems that we had before are continuing. So issues with confusion over social security coordination and competent state issues are continuing and getting worse. Issues with making decisions on an EU national's right to reside, to access benefits, getting worse, continuing. Issues with worker status, continuing, getting worse potentially. But now we're actually in the grace period, this 6-month period, that individuals have rights stemming from their residence in the UK, rights stemming from the EU settlement scheme, and any new arrivals have, as Charlotte mentioned, a whole new set of rights. And so we're finding that during this time, that confusion of the overlapping rights individuals are having are making these problems so much worse. And confusion is leading to really bad decision making, and individuals are being cut off from their rights. Some examples we're seeing of this is individuals with pre-settled status are kind of being told by decision makers that they have no access to public services and welfare benefits like universal credit. A specific example being, we saw a local authority applying this to the housing waiting list and telling individuals with pre-settled status that they weren't eligible without checking any other right to reside that they might have had to establish that eligibility. So we can see that as things go on, the confusion is adding up, and there's different dates flying around, different statuses depending on what your status is under the EU settlement scheme, and it's just creating a lot of confusion and a lot of errors. And so they're kind of the early issues that we're seeing. But I'm going to hand back over to Charlotte, and she can give a bit more information on our concerns with the deadline going forward.
Thank you, Alice. I told myself I was on mute. Now, the deadline that's imminent, that's pressing, is the 30th of June 2021. It's the deadline for applying to the settled status scheme for EU nationals in the UK. And that is 93 days away. I've got this little clock going on in my head. I can't stop it from ticking down, because that's not very long. And there are a lot of people still who have not registered or applied. It's a process of application, not registration. And there's still concerns over levels of awareness, particularly amongst socially excluded groups. And the consequences of falling off the deadline are very severe, because apparently, at the UK's insistence, the withdrawal agreement provided for allowed the UK and member states to create a constitutive scheme. That is, you must have the status in order to continue to exercise your right to reside. And if you don't have it by a deadline, then you lose it. And unless you have good reason for not having applied in time, then we're talking an irreversible loss. That people's rights that have, in theory, accrued over a potentially very long period of time, people who have lived in the UK for years, people who were born in the UK, people who've been working in the UK and contributing in the UK, even people who have EU permanent residence, the thing that's about to turn into this fatal oxymoron. Permanent residence is going to become terribly impermanent, and people don't necessarily realise that. And as a consequence, we're looking at people suddenly losing all that and not being able, if they haven't got a good reason for having applied on time, not being able to rely on any of that meeting those substantive conditions. And a number of organisations have done quite a bit of research on this area. So we've seen the Social Market Foundation published towards the end of last year a study showing a high and worrying degree of ignorance amongst some low-income workers in the Fenlands of the scheme's existence. And the JCWI also recently published, I think it was earlier this year, a study on care workers, and again found worryingly high numbers of people who did not know that the scheme existed, or if they knew it existed, did not know that they needed to apply. Now, the thing with deadlines, as anyone who works in academia knows, is people miss them. And it feels a little bit like there is a certain amount of head in the sand around this issue. So when being questioned, was it 2 years ago, the then Home Secretary said, well, the aim was to ensure no one would be left behind. But it's been clear from the start that there will be people left behind. And there's very little information in place as to how to deal with that. I mean, what we have seen is recently, through an announcement on a local authority bulletin, that the DWP is now planning on working with the Home Office, liaising together to contact people who they have on their books because they're on benefits or they've applied for benefits, who don't yet have settled or pre-settled status, in order to prompt them to apply. But they're going to do this in April. So a couple of months before the deadline. It's not at all clear why this has been left so late, given that this is a body of data that has been available all along, that there could have been a little bit more encouraging going on. Again, given the severity of the deadline. And the impacts that we're talking about here are, we have argued, are disproportionate in terms of failure to comply with an administrative requirement at a particular point in time, suddenly seeing huge swathes of rights disappearing overnight and irreversibly, is not a proportionate penalty. And so we are putting together a proposal, which we're working on a briefing at the moment. Anyone who's interested, we're very, very happy to circulate it. Working up a suggestion that the choice is not just between a constitutive lose everything if you miss it scheme, or a totally declaratory scheme, which we're aware the government were concerned that people would then be under the radar, and there will be many, many years of them not being documented and then facing problems further down the line. That in fact there's there are ways along the spectrum of having a substantive scheme whereby people do need to have the status in order to access certain key rights, and therefore they are prompted at various points in order to make that application. They're very unlikely to go for a long period of time without having made it. But if there isn't good reason for having applied on time, then you're talking potentially a fixed sum penalty fine, like if you submit your tax return late. But there would then be waivers potentially. So that's one of our key proposals that we're working up. And I will hand back over to Alice to talk about another one.
So another issue that we have with the EU settlement scheme at the moment is there isn't a lot of information about how accurate the decisions are. There's an option on the application form to state that you believe that you've been in the UK for over 5 years. And so the Home Office should have that data and be able to compare it to the data of whether those individuals who say they've been here for 5 years do get settled status. If that happens, then they should be able to see how many people are actually getting pre-settled status who think they should be getting the better settled status. And that's important because pre-settled status has some significant problems with it. The first of which is it has restrictions on access to benefits. If you have settled status, you're believed to have a qualifying right to reside, which gives you access to benefits. However, the government introduced regulations that meant that those of pre-settled status were excluded from having that right to reside, and instead had to establish a right to reside through the EEA regs, which is the older route through being a worker, through self-employed, a family member, many different ways to do it, but significantly harder than just having settled status. There's been a successful challenge of those regs in the Fratilla case in the Court of Appeal. Those regs were quashed by the Court of Appeal, but it is far from over. There's an appeal to the Supreme Court on that case. The quashing has, the effect of that quashing has been stayed, and there's also an additional case come from a tribunal in Northern Ireland who have referred the very same question at issue in that case to the Court of Justice of the European Union, but in a different case. So those are running alongside each other. They're both being heard in May. So we should get decisions relatively quickly, we hope, but there's still a lot going on. It's still up in the air. And even if those cases, even if the Secretary of State loses those cases and people with pre-settled status can establish a right to reside through that status, there's still a question of whether that extends beyond the transition period. And we're likely to see ongoing litigation in a kind of Fratilla Mark II case that will kind of try and establish that right to reside for people with pre-settled status ongoing past the end of transition. So it's quite important that people get the right status. Individuals might get the wrong status and only realise at the point where they make an application for benefits, and then realise that they should have actually fought to get that status corrected, or not even realise that they were given a different status to what they thought they were going to get. The other major problem links back to what Charlotte was talking about with deadlines, which is that if you get pre-settled status, it's only temporary. And what this essentially does is create a whole number of deadlines, personal deadlines to individuals over the next 5 years as to when they, when they qualify for settled status, but also for the 3 years that the scheme has been open, those 5-year cutoff dates where pre-settled status was awarded, but it only lasts for 5 years, it's just going to create a whole number of cliff edges for individuals who need to know that they have to apply for settled status by that time. And there's no opportunity for a big media campaign around one particular date that we've seen with the EU settlement scheme. So the government has been concerned about the idea of automatic transition to settled status in these cases, because they're concerned that individuals will not meet the requirement for settled status, will not have the necessary residence requirements, might have gaps in residence. So we have come up with an alternative plan, which would be a kind of assisted transition and a streamlined transition from pre-settled status to settled status. And this would require something like a link sent to individuals with pre-settled status where they can make a declaration that they meet the requirements and provide details of 2 references, which the Home Office can conduct random checks on those to satisfy that they do meet the requirements. But at the moment, as things currently stand, we have no idea how they're planning to do this. If they're requiring people to make applications similar to what they've done with the EU settlement scheme, we could see a significant number of people who have pre-settled status now, so are not a concern for this current deadline, end up losing that status just 5 years later.
Thanks, Alice. And just quickly to sum up, I just wanted to say that 3.5 years ago, thereabouts, when there was the first iteration of a withdrawal agreement, I made 5 predictions. Now, lawyers in general don't like making predictions. We watch and we wait and we criticise whatever happens. But nevertheless, I stuck my neck out and I came out with that there would be surprise evidential hurdles, that women and children will fall through the gaps, that there will be definitional arguments, which I appreciate is the lawyer's equivalent of a horoscope, really, of course. There will be definitional arguments, that decision-making machinery will be congested, and that things will go wrong. And I think that there is evidence that all of those fears or concerns were reasonably well founded. Things are going wrong. All law in general is subject to Murphy's Law. If it can go wrong, it will. But I think it's important that we try not to be too overwhelmed or resigned to the frictional injustices that we're seeing happening already, but to do our best to protect, and that's what we're hoping to try and do through the hub, is to protect those who are caught in the middle from discrimination and destitution. Thank you.
Thank you so much, Charlotte and Alice, for that very comprehensive and also informative presentation. I think that in particular, given everybody is using this platform to, inform EU citizens of various things, we have to highlight that the settlement scheme is ending on the 30th of June, which is quite interesting because I had a class last week where I was talking about the deadline and asked the students, does anybody know what the deadline was? And one of them said, is it the 21st of June? And it turns out they had mixed that up with the end of lockdown or end of restrictions. So I hope that anybody involved in all of this does not get all of the dates that are being thrown around out there mixed up. But yes, thank you so much, Charlotte and Alice, for bringing attention to all of these issues. Lots of great questions to come. I think very nicely, your presentation leads on to our final presentation of the evening by Andy Cyril, who is the legal director and partner at a human rights charity, Just Rights Scotland. And Andy's presentation is going to be about the vulnerable parties that he works with or has worked with in the past under the EU settlement scheme, which swings very well on from Charlotte and Alice's highlighting of those people who do indeed or may indeed fall within the cracks. Indeed, my own research is very interested in this as I'm looking at women who are falling within the cracks of the EU settlement scheme. So I think Andy will be speaking a little bit to that, and I look very much forward to it. So take it away, Andy.
Thank you very much. Thank you very much. Good evening, everybody. It's nice to be here. So let me just share my screen for a quick second. There we go. That should work well. Hopefully everybody can see it. So I'm following on from that excellent previous presentation and we'll probably be bringing some of those themes that we're speaking about into direct practice. So just a quick word on my organisation for context. We operate 4 legal centres within our organisation. We've got the Scottish Refugee and Migrant Centre, the Scottish Women's Rights Centre, which is government funded, working with survivors of gender-based violence. We've got our Anti-Trafficking and Exploitation Centre, which does what it says on the tin. It's a centre that works with survivors of modern slavery, trafficking and exploitation. Just Law Centre, which is a strategic litigation unit looking at disability, justice and trans justice. And we've got a think tank there on the side. But within all of these centres, we work with, in various ways, either directly with the EUSS, the settlement scheme, or on issues that completely affect the EUSS. So we operate various collaborations through our legal centres. We have law clinics working for EEA homeless persons. We have taken strategic litigation looking at the changing of the gender marker on an EUSS status document. And my own personal specialism is in working quite intensely with EEA children in care and domestic violence survivors as well. And I suppose where I would start is that the Brexit, and as the other presentations have alluded to, has thrown into sharp light the need for statutory authorities to have a good understanding of immigration. And this is a really difficult thing because immigration law, as a generality, is probably our most complex area of law in the UK, on the basis that it changes with basically the direction of the wind. There have been over 46,000 changes in immigration law, well over 46,000 changes since 2010, and the immigration rules have doubled in length at least. And that's only getting more complex now with the additions that have been bolted on as a result of Brexit. But statutory authorities who are on the front line in protecting vulnerable people are key in considering how this works for the next period of time, I would say. And in my experience with situations like the EUSS, with schemes like the EUSS, it's always the most vulnerable that fall through the net. So these are common situations we hear a lot from statutory authorities, including social work departments. You know, I'm not an immigration lawyer. Immigration status has got nothing to do with us. I don't like talking about immigration. I feel like I'm racially profiling. I don't understand British nationality law. It's very common for local authority workers to be working with somebody who they think is a migrant, but who is actually British. But equally, they also may be working with somebody who they think is British, but is actually a migrant. And that creates all sorts of chaos if it's a young person, you know, growing up and trying to access services, or if it's a vulnerable person needing to access safeguarding services that they cannot do so. They don't understand what immigration status really is. That's also a relatively common one. For those of us who are entrenched in it, that seems inconceivable. But for those of you who are not, the lucky ones, it's not something that they think of terribly often. And I don't think immigration applies to children. That's also a very common one. What I would say 3 years on is that we know what we don't know now. We know, if I focus in on children in care, which I will with a couple of case examples in the time I've got available, we know that local authorities don't know how many European children we have in care or where they are. And when I talk about those children, I'm talking about EEA children, but I'm also talking about the non-EEA children of European citizens, and actually there can be non-European children of non-European parents, but who are in European families that are affected as well. And we just don't know where they are. I don't want to preempt anything, but you'll see tomorrow there's going to be some new information hitting the news with statistics around this problem. We believe from those statistics that there is a massive underestimation of where these young people are. And we're also seeing that actually less than half have actually made applications to the EUSS. Super worrying. So the conversations that are being had in the previous presentation looking at deadlines, it's inevitable we're going to see highly vulnerable people fall through that net. Some of the key things to understand about working with children in care: immigration status of accompanied children is often dependent on others. The right to reside within European law is often dependent on a parent or a partner. If that main status holder breaches their right to reside, then very often anybody who's dependent on that, they fall in breach as well. And when you take a child into care, you very often are breaking their status. You are making them undocumented very often by the process of taking them into care. These are fundamental concepts that actually are pretty poorly understood. And then when we think about survivors of domestic violence or children, it's very often that they do not have either possess their own immigration documents or identity documents, or they don't have access to them because of an abuser or an abusive parent. And that applies equally to European and non-European individuals as well. Let me give you a couple of examples of some of the practical complexities we're seeing on the ground with this client group. I've changed the one or two details with respect to this case example for confidentiality reasons, but these are real cases. Marguerite is a 16-year-old Ghanaian national. She's brought to the UK by her auntie, who's a Danish national, on an extended family permit. There's domestic violence and she flees the home. Social worker paying for her to live in a bed and breakfast, but she receives no other support. And when you take a case like this, there are all sorts of questions and all sorts of unknowns that are there. Does Marguerite have the right to reside in the first place now that she has left? The local authority are seeing a residence permit that says, yeah, sure, she's got the right to reside until 2023. That's fine. They've seen that it's a European residence permit and they're maybe thinking, is there something to do with the EUSS here? She's from Ghana. She's not relevant for that. What do we do? The reality is that she did have the right to reside, but when she fled the domestic violence scenario, that broke because her status that she had was dependent on her aunt. So she's now undocumented. So we know she's undocumented. That means that she's NRPF. That means no recourse to public funds. Local authority are thinking, well, we don't need to do anything here. Wrong. They have obligations to this young person as a survivor of domestic violence, but also as a child in terms of promoting and safeguarding the best interests for her welfare. Does Marguerite have the right to apply to the EUSS? Yes, but when the EUSS was conceived, no. It was only in June last year that children who have fled domestic violence were granted some form of special designation within the EUSS where they could apply to the EUSS scheme. Actually, when I took this client on, that rule didn't exist and the EUSS was blocked for her. Can you imagine that? A single separated child, survivor of domestic violence, here because of a European family member, but blocked out of the EUSS. Thankfully, that rule changed and we were able to make an EUSS application. But think about the evidence that you need. You're needing to show previous dependency on an aunt, withholding identity documentation, etc. All sorts of problems there as well. The second example, 3 children, John, David and Sam, 3 brothers from Kenya, aged 5, 3 and 14 respectively. They're brought here by their father, who is also Kenyan, married to a Czech woman. After various incidents, they're brought into the care system. Their father's not cooperative and refuses to provide any information or documentation. Do the boys have the right to reside? Same types of question. Yes, they do. And that is, again, something that the workers, the professionals in the boys' lives will not associate with at all because they're not European, dad isn't European, But the fact that dad is married to a European and they're his kids, they actually do have the right to reside. And there's no dependency requirement on that either. They don't need to be living in the same household because they're under 21. So actually, they might be separated completely from dad, but they still do have the right to reside. They can apply to the EUSS. In terms of what evidence they need, though, well, they need to prove that they are the child of a non-European who is married to a European, who has the right, well, yeah, married to a European. So we're thinking passports, birth certificates, DNA, marriage certificates. What do you do when the dad is refusing to hand these things over? We had social work in this case go to his house to try and ask for these documentations, literally pleading, this is for your children. And he was shouting at them from the top window, go away, in not so pleasant terms. So we need to be creative when we think about how to access evidence in order to clear these barriers. And then you think, are there other issues you see? And this is a key red flag issue. John, the youngest, 5 years old. He's too young to instruct a lawyer to do an EUSS application for him. Social work cannot do it. They're not OISC qualified. Parental rights and responsibilities sit with dad, who's not cooperating. So there's nobody with parental rights to instruct on his behalf. Now, children's law is different around the constituent parts of the UK, but this is a key problem. In Scotland, for example, there are children that are too young to go through the EUSS, and the solution of, oh, social work, just do it, is not fair, really, to be honest, on local authority workers dealing with cases of this complexity. So these are issues to always think about just as I wrap up. What's the current immigration position of the individual? And how does that affect their rights and entitlements? When you're working with vulnerable individuals, whether it's homeless, a destitute, domestic violence survivor, child in care, you need to be trying to secure their immediate health and well-being, right? That's got to be your number one priority. Through hook or crook, it needs to happen. And so often that hinges on their immigration status. Is there a route into the EUSS for them? Just because they're not European or just because their parents aren't European doesn't mean there's not, right? It's more complex than just a European. And our statutory authorities and professionals in the lives of working with these individuals, whether it's somebody in a women's aid refuge or something else, has to have that level of understanding. Evidential barriers, where there's a lack of documentation. These are big problems. However, there are solutions as well. You can apply for paper application forms. You can think of other forms of identification to give. Are there creative ways to get that documentation? I just made an application this morning for a marriage certificate, which is actually a public record. £12 it costs. And something that was previously unobtainable because of an abuser is now obtainable. And does the child have capacity to instruct? And if not, what then? These are real difficult issues. Finally, UKVI and local authorities are under an obligation to promote and safeguard the best interests of the child. As lawyers, it's critical that we harness that in order to make sure that local authorities promote and safeguard from a immediate safety perspective, but also understand that immigration status is key to them fulfilling their duties. It's not something that's related to central government. It's something that's intimately related to their own profession. Non-EU citizens might be born British or eligible to register for British nationality. British nationality is very complex as well. I would probably hazard that most of the participants in this call, or many of them, will not know what type of British citizen they are, whether it's by descent or otherwise by descent. That's a very, very common distinction that people tend to get wrong. And so where there's an eligibility for citizenship, well, do we go for that? But there's also this question that you always have to have in the back of your mind as a lawyer working in this area is, what are the benefits and the drawbacks of the different options that are open to you for that individual? Do you want them to have a route that actually has a form of dependency? Or is it better taking the harder road for something that gives them status in their own right? These are all key issues. And that is where I'll finish there with some contact details.
Thank you so much, Andy. Again, really important issues to bring to light, and highlighting very much the confusion, I would say, around a lot of the rules and the laws in this country around immigration, nationality, etc. So thank you very much for that. I'd like to invite all of our panelists back so that we can start to take some questions, if that's okay. You will see a number of questions in the question and answer section already, and I was trying to figure out the best way to do this as there are many, and I think it's a good discussion that we can have. So I thought I think I'll just do them in order of how they come, so we can get a bit of a spread of everybody speaking. So if we can start with, I think, the question for Rhys from Professor Tammy Harvey. Would be interested also in everybody else's views, so please do feel free to chip in. Tammy mentions that Jill Rutter of the Institute of Government called on the IMA in a blog on the 23rd of November last year to meet 3 crucial matters. The first is to monitor impact of lack of physical proof of status. Number 2, to make sure there is a clear plan for after the 30th of June 2021. And the third, making the move from pre-settled to settled status smooth. And I think everybody would love to hear how it's all going. So Rhys, if you'd like to let us know, then we'd love to hear from you. Thank you very much, Tammy, for that question.
Thanks, Adrienne, and thanks, Tammy, for the questions and all the other questions. Exceptionally high standard of questions coming in. Really interesting questions being asked. Specifically in terms of the Institute for Government's report back in November, I do recall when that came out, and we looked at it at the IMA with interest, because obviously it helped to form or help to inform how others saw the role of the IMA, which is an important element that we took into account when we were looking at what our initial actions would be. In terms of the specific things that the blog referred to, those issues are part of a whole myriad of issues that we are currently considering at the IMA. Now, we have been active for the last 3 months, and those are all issues that we are acutely aware of. Those are issues that we are looking at, along with a number of other issues. We are looking to engage with the relevant public authorities concerned, to work closely with them, to understand issues from both perspectives. And I think something that I didn't necessarily touch on in my opening, which I should have done, is our desire, where possible, to seek early case resolution on a number of issues. Some of these issues highlighted in the IFG blog may not be something that would fall into that category, but if we're looking at the solution that would best serve the citizens, then the early case resolution is something that we are actively trying to encourage, but through active dialogue with the relevant public authorities concerned. And I think one of the things I would mention there is and I think this is where we are perhaps in a slightly better position than some other organisations, is the duty on the relevant public authorities concerned to cooperate with the IMA insofar as that is reasonably practicable. So I think we do have the ability to ensure that these relevant public authorities do listen to us and do engage with us and do answer our questions, so that we are then in the best possible position to assess all the relevant information, take a view on whether inquiry is merited, and if we do conclude in a breach, to make recommendations and, where appropriate, take legal action.
Thank you very much, Rhys. A very comprehensive answer. I hope that answers your question there, Tammy. I want to move on to the second question, because I think there are, all these legal questions, and maybe address it to Charlotte and Alice, unless anybody else would like to chip in, from Theocharis Ladakis regarding naturalization and comprehensive sickness insurance requirement, the famous CSI, for student years. Is there some information if this is legal, considering EU students pre-Brexit were covered by the NHS or not? If not, is there some action taken against it?
Well, I can't speak to the point about naturalisation as such without going away and looking into it. But as regards the comprehensive sickness insurance requirement, as it's been deployed in EU law and potentially withdrawal law, there is a challenge ongoing. It's like the one Alice mentioned. It's another first-tier tribunal in Northern Ireland that submitted a question on how far the NHS or eligibility for NHS treatment or coverage ought to help one meet the comprehensive sickness insurance requirement. So that might have a knock-on effect onto what it is that the question is asking about.
Yes, I understand naturalization and all of those processes are quite complicated, so perhaps not the expertise of our panel today. Thank you so much for that question as well. Next one from Jonathan Collinson is one I would like, I think, to open up to the whole panel and maybe ask Michaela to kick off on from a different perspective, because we don't want to forget the British citizens in the EU, and that's the point of having that representation there. To what extent is confusion and complexity leading to poor decision-making and cutting off of services a feature, not a bug? For example, how much of the problems that you're discovering a function of discouraging EU nationals to assert their rights after Brexit, and perhaps to Michaela, for British citizens to assert their rights after withdrawal?
So it's an intriguing question, Jonathan. I think that it's undoubtedly the case that this has been an incredibly confusing time, and that any solutions that were reached were going to be incredibly complex and lightly confusing. I mean, I think that we've seen from all of the presentations the extent of that. And just to kind of put the British citizens in the picture, what we've seen today from the presentations is how confusing and complex it is in the UK. Now, imagine in the case of British citizens in the EU, where you're dealing with, I'm going to say 26 member states, because Ireland is its own special case. And so actually what I was seeing when I was working with British citizens living in the EU, doing in-depth research with them about their experiences, was exactly how that complexity and confusion that we have in the UK for EU citizens is multiplied by the number of member states. And I think that this is a really something that's often overlooked. I mean, I don't think that I would go as far as to say that it's by design. I think it is a factor of, it's an outcome of the fact that these things were incredibly entangled all the way through. And as you can see from Andy's great presentation there, sometimes people need to have their attention pointed to some of the exclusions that they've built into a system in order to realize the limitations that they've put into place. So yeah, that's kind of my contribution to the question of confusion and complexity.
Thanks, Michaela. Just to highlight that, of course, it's confusing for British nationals as well as for EU nationals after Brexit. Andy, do you want to speak to this? And also, apologies, as I hear you can speak to the naturalization point that is so confusing to us all.
Yes, so I do like complex naturalization applications for my sins, and I can say that just to add to what Charlotte said, obviously it was very unwelcome when we were told via guidance that the Home Office are going to be looking at 10 years of right to reside / lawful residence for EU citizens naturalizing. What I would say is that the new it is just in guidance as far as I understand, and the new proposals from the Home Secretary, which were announced last week, there was a diamond in the pile of rough, which says that there's going to be a discretionary element added to naturalization applications for adults, as there are for registration applications for children. So children can apply to register as British even if they don't meet all the rules. Adults now will be able to as well, and that's off the back of Windrush, where people were being deported from the country, and then the lack of residence was being used against them in their citizenship applications. So I would be relying heavily on that in any EEA naturalization application I would make where you didn't have CSI when you were a student, because quite frankly, who cares, basically.
Thanks, Andy. I want to move on to the next question, as we've got quite a number to get through, and I'd like to get to as many as we could. Tammy asks Alison, Charlotte, the EU-UK TCA also includes rights for migrant citizens in the social security sphere. What is your plan for giving second-tier advice on those issues if they arise? Charlotte is definitely right that the regimes are indeed quite different.
So we have been, as you can imagine, looking into analysing the social security coordination provisions in the TCA, and these are likely to trip people up, even those who are very well versed in pre-Brexit social security coordination, because the regime is so different in terms of not creating individual rights or direct effect and so on. And there are some key differences. There's a lot that's replicated, and there's quite a bit that's different. And we are going to be able to advise and support to the best that we can people who are making those kinds of claims. I'd imagine that it might include UK nationals who are going to another member state, or to a member state, I need to stop saying another, or indeed EU nationals who are going potentially back to their home state or to a member state and wish to export benefits under the TCA arrangements. And yeah, I mean, very little to say beyond. We are going to be interested in seeing how that goes. I don't have a huge amount of optimism in terms of how smoothly it's going to go, because my key takeaway point on social security coordination is that it was already really messy and didn't work very well for an awful lot of people when the UK was a member state. So it's a case of watch this space and wait for the chaos.
Hopefully that does not happen, but we shall see, shan't we? I might collect a few questions for Rhys, if that's okay. So another one from Tammy Harvey. Are there any common law principles reasonable, for instance, that may apply to a failure to miss the 30th of June deadline, which is slightly connected to another question from Kyla and Tenna about the fact that it's very clear EU citizens have been facing these serious issues of confusion about getting a status to settle here in the UK. And do you think this goes against the rights of EU citizens under Part 2 of the withdrawal agreement? And would the IMA perhaps take any action against this?
Thanks, Adrienne. Yeah, I think in terms of Tamara's question, I guess it applies in terms of the applicant. I think in terms of any reasonableness that would apply to their inability perhaps to have met the deadline. So obviously the withdrawal agreement caters for that possibility in terms of late applications, and there is reference to a reasonable further period for late applications and for an assessment to be made of the reasonable grounds for the failure to respect the deadline. So that is brought in terms of when looking at late applications. I'm not sure whether that was the question, but I think that brings the concept of reasonableness into the assessment of late applications. And in terms of Kyla's second question, then I think in terms of whether the IMA would be acting if we felt that these serious issues that have been identified on this talk and elsewhere. Now, obviously, the IMA is at the moment in the mode of collating as much information as it can about all the kind of issues that EU citizens face, and we are using that information to inform what we do next. If we feel that there are these issues that need to be resolved, then we will be taking action by first of all approaching the relevant public authorities concerned, and then going further to consider our other options if we cannot resolve the issues at that stage. And if we feel that there is a breach, then we will be actively looking to use our inquiry functions and any other legal action that may be required following on from that. So I think if there is a breach, then that is something that the IMA will be actively looking at.
Fantastic. And then perhaps following a little bit on from that, which is also from Kyla, how would you balance your administrative power in making sure you monitor the implementation of citizens' rights in the UK, but also ensuring that you respect the independence of the UK courts and the government decide in citizens' rights cases, especially now that the UK courts are not obliged to ask for preliminary rulings in the CJEU?
Well, I think the first thing I'd mention is that evidently for the next 8 years that the references can be made to the Court of Justice in terms of the interpretation of Part 2. So that's the first point I'd make. So that will continue to be an important element of I suppose, how Part 2 of the withdrawal agreement is interpreted going forward. That's the first thing I'd mention. And then the second thing I'd mention in terms of our need to respect the court, so the IMA's need to respect the court and government. So obviously, we obviously respect any rulings that the courts, whether domestic or the Court of Justice, would rule down, and take those into account as we exercise our functions. I think in terms of when it comes to respecting the choices of government, evidently governments are elected, and there is a question of democratic accountability of the choices made by government. But I suppose what I would emphasize is that our focus is on how those government choices comply or not with the withdrawal agreement or the EEAF, the separation agreement. So while, yes, we are respectful of the democratically elected government, that is not to say that if we identify a breach that we will not hesitate to look into those issues and take action as we consider appropriate.
Thanks very much, Rhys. Moving on to our next question from Luke Piper, who asks the panel, so I might ask Alice to start with this if that's okay. Other than moving the deadline, what do the panel believe are other measures that could be put in place to mitigate the impact for those who missed the deadline? So very much the question of the century, I think.
I think that, I know you said other than moving the deadline. My first thought is always that it's just bonkers that the deadline isn't being considered to be moved, especially given the last year that we've had, the impact it's had on organizations that were helping vulnerable citizens, actually being able to reach out to them, to have drop-ins and stuff, and the effect it had on the Home Office to be able to have the EU Resolution Centre open. I think it's absolutely wild that we're not even considering moving the deadline. But alternatively to that, I think that, you know, the idea of having a way that individuals don't lose all their rights is the most important avenue to go down, which is what Charlotte touched on when we were speaking earlier. Just having the ability for individuals to gain back that proof that they have lawful status to be in the UK and or have been here for 5 years previously. It's an incredibly cruel punishment to make someone lose all of that just because they missed a set deadline.
Thanks, Alice. Anybody else? Yes, Charlotte, go on.
Yeah, just to add to what Alice was saying, on the point about the deadline, I mean, the idea that that this is an inevitability that was somehow tied to this 30th of June deadline really needs challenging, because of course the withdrawal agreement allows for it to be a lot later. It said it had to be a minimum of 6 months from the end of transition, and the UK went for the minimum possible period of time. And when we look at what other member states are doing, 13 member states have not introduced a new regime, a new status, and therefore there is no cliff edge deadline in 13 member states. Of the remaining member states, only 6 have opted for reciprocating the UK's tight deadline and gone for the 30th of June. 2 have gone for September, the end of September, and another 6 have gone for the end of December. So, you know, we're really in the minority here.
Thank you very much. Yes, it's really interesting to hear that. Mikola, I wonder if I could ask you then, like kind of related to that, not to abuse my position as chair, about British citizens and EU member states constitutive systems as well.
Yeah, I mean, so this is where the fact that I worked in France comes in particularly helpful, because France has a constitutive system that they're rolling out. And I think that some of the writing has been on the wall for a long time about how that would fall for British citizens living in France, because already in advance of France bringing in its system, there were British citizens living in France who were, for a variety of reasons, going to apply for EU residence permits, which are not compulsory in France. You don't need them for anything, and so are not regularly processed by authorities either, even though they do exist, and being found that they weren't lawfully resident by the conditional terms of free movement. So that was just the tip of the iceberg. France offered a really good case, I think, in terms of seeing where the gaps might be when it came to British citizens living in the EU, all of which will be exacerbated by a constitutive system, basically. So that's really what I wanted to highlight when thinking about France. So we'll see, you know, the cases that I knew of tended to be women who were older, who had very low incomes for a variety of reasons, including the loss of a partner, included chronic ill health. I mean, it's kind of almost textbook, really, in terms of who's likely to fall between the gaps. So yeah.
Which I think speaks very well to a little bit about, you know, who Andy was speaking about in terms of who falls within gaps. I wonder if you wanted to also ask your question to Andy, actually, now that you have been speaking, Nicola, about children in care.
Yeah, I mean, it's a question, Andy. I was really fascinated to hear your presentation, because repeatedly with speaking with British citizens living in Europe who are campaigning for citizens' rights, the question of what's happening to British children in care in the EU has come to light. And of course, all of the problems around statistics, all of the problems about who has responsibility for them are the same, but again, 26 member states. So I just wondered if you knew of any work that was happening that I could share with other people.
I'm very sorry, I do not know of any work that's looking at British children in care. And I'm trying to think of whether there's any agency here in the UK, statutory or not, that would be able to help you. But I'm drawing a blank. All I can say is I hope the experience within the EU is better than the experience here.
Thank you, everybody. So to move on quickly to a couple more questions that we can squeeze in before the end. I suppose to kind of everybody, but specifically to Charlotte, Alice, and perhaps Nicola. Eleanor Svaventa said that EU and British citizens have been treated as bargaining chips throughout this whole Brexit process. I think many people have also said that, apart from Professor Svaventa, and that they have not been treated as fairly or as well as they could have. How far do you agree with this statement?
Well, I agree up to a point, but to be honest, I think it's worse than that. I think it's worse than bargaining chips, because bargaining chips would suggest that they're being treated poorly in some way to try and extract or leverage some advantage for British citizens in the EU. And actually, I'm sure Nicola's got something to say about this, but the impression I get is that that cohort has been largely cut loose and not really protected by the government. And I mean, if anything, what we've seen in the negotiations whereby the EU was not necessarily standing by offering a constitutive scheme that would see people losing rights, but it was the UK negotiating team that insisted upon it. And now we've got Michel Barnier slightly backtracking and saying, we want member states to be generous. So if anything, what we have is, you know, EU nationals being treated as some sort of collateral damage for its own sake, rather than bargaining chips, which I'm not sure if, yeah, it strikes me that there's less of a coherent negotiating logic to it than bargaining chips would suggest.
Yeah.
Alice, do you want to add anything to that? No? Okay, Nicola, go ahead.
Yeah, sorry, I can definitely come in on Charlotte's point there. I completely agree with her. I mean, there was a real fundamental difference in the way that some member states were speaking of their citizens in the UK when all of this started to play out, and how the British government, in Charlotte's words, cut loose the British citizens who live in the EU. My overwhelming sense of what happened to British citizens living in the EU was right from the start, all the way through the campaign, where those of them who'd lived overseas for 15 years or more did not have a right to vote in the referendum, which would ultimately impact on their rights. All the way through the campaign into the kind of the initial stages of the kind of outcome of the referendum, into the negotiations, it really felt like British citizens were out of sight and out of mind. And where we see British citizens being referred to in public, like in the pages of the newspapers and everything, those kind of stereotype and caricaturing images of, you know, old age pensioners sitting on the Costa del Sol were the prominent representation of British citizens living in the EU. And yet nearly 80% of British citizens who live in the EU are of working age and below. And most people wouldn't know that. I mean, along with Andy's points about the vagaries of British nationality law, you know, British citizens who lived in the EU are a major population. It's a huge number of people to live abroad. And yet their own government, the one elected body that they might have been able to call on to support them, really didn't, you know, just even the tone of their communications around this suggested that it wasn't within their gift to do that. That was within the gift of the EU. So I do ask the question of why EU member states thought that they could appeal on behalf of their citizens living in the UK, but that the British government really did not.
Thanks, Michaela. I'm going to ask two more questions very quickly before we wrap up. One to Rhys, the very obvious question from Tammy Harvey, which is on everybody's minds, is to ask Rhys what his organisation is planning to do for the children whose circumstances, which Andy so nicely outlined, and thousands of other children like them.
Yeah, thanks, Adrienne. Yeah, Andy's presentation, a very powerful presentation, and brings to stark I suppose light the impacts that the EU settlement scheme and the withdrawal agreement and everything else is having on individuals. So obviously, where we are seeing such examples, we will investigate. We will look into the matters. We will see whether there are general systemic failings that have resulted in those individuals being in the positions that they are. And where we see that those failings are a breach of the withdrawal agreement, then we will use our powers appropriately to hopefully remedy the situation.
Great. Thank you very much, Rhys. Big thumbs up from Andy there. Very happy to hear that, I think. So I think to end, we can ask a question to the panel from Nicholas Sadeghi. Given the Home Office's hostile environment policy, does the panel agree that the practical value of the EUSS is significantly undermined by the fact that successful applicants are not issued with any physical proof of their status, similar to the biometric residence permits issued to non-EEA migrants? Perhaps I can ask Alice to kick off on this for us.
Yeah, there are some really big concerns about digital status. I think it clearly does undermine the point of the settlement scheme, because it essentially there's a risk that people who can't access a digital status are going to be detached from their lawful residence because they won't be able to access it and prove it. However, it still has value because it's still there so people can use it to challenge decisions that have been made on the basis of somebody not being able to show their status. However, that doesn't negate the fact that there's going to be some big problems down the line. It's important to note that at the moment, status under the EU settlement scheme isn't required because of the grace period, so people can still rely on their national ID cards to access, prove their eligibility for services. So I don't want to make a scary prediction, but I imagine this is something that is going to pop up a lot as soon as that deadline kicks in, as soon as we hit July of this year, because people are going to be relying on this digital status, and so we'll start to see the pitfalls of it straight away.
Thanks, Alice. Andy, do you want to comment on this as well for your work?
Yes, and I'll be brief and probably more forthright than Alice there. I think it's a terrible idea, and it will either, this is my prediction, taking a leaf out of Charlotte's book, it will either not, the plans to digitize all immigration status in the UK, you know, the government is planning it to apply it to every single migrant, refugees, limited leave to remain, everything by December 2024. That will either not happen because sense will be seen, or it will happen and it will be a catastrophe. We're in a situation now where people don't understand what we have, a card with like very clear English writing written on it. And when I'm talking about people, I'm talking about statutory services, employers, landlords, marriage registries. The hostile environment is such that everything is placed on this card, but that gives us something tangible. Without that tangible thing, the wheels will come even further off the bus. It is a bad idea, in my opinion.
Thanks, Andy. Reese, do you want to say anything to this?
Sorry, I struggled to get off mute. Yeah, I think, look, I think from our perspective, we just need to be clear what the issues are and how we can ensure that what we do is, or how we can ensure that our monitoring function is appropriately informed by all the information out there. And I think this kind of goes back to something that Nicola said earlier in her presentation around the real impact on people. And I think that's where the IMA needs to have the information at hand to help it inform what action, if anything, it needs to take. So I think that would be the key for us.
Great, thank you. Nicola?
I don't really have very much more to add to those accounts of the digital scheme, other than the fact that I think we should see the digital scheme as integral to the hostile environment. It is the hostile environment. These modes of governance are there with purpose. So yeah, that's all I have to say.
Thank you, and perhaps we can end with Charlotte's views on it, if anything else to add.
I think everyone's covered it. Yeah, I back up entirely what everyone has said, and also just re-emphasise that along with many other aspects of the EUSS, we're talking disproportionate impacts here. We're talking potentially discriminatory impacts falling upon particularly vulnerable minorities who are more likely to suffer as a consequence of the digital scheme.
Yes, and I think that it just goes to show that it's so important for us to do all of this research and do all of this work highlighting, the positions of these vulnerable people, as Andy and all of the rest of our panelists as well have done today, highlighting the work where you can go to complain, and also not forgetting, of course, the EU, the British people in the EU. So thank you so much to all of our panelists for some fantastic discussion, fantastic presentations. I must apologize if we did not get to your question today. It's been very rich, the discussion, and I don't want to keep anybody from enjoying the new British summertime sunlight. So just remains to thank everybody for joining us. We really appreciate it. Hope to see you all at another event very, very shortly. And I hope that you all learned something, and don't forget that the deadline is the 30th of June for the EU settlement scheme. So thank you very much, everyone.